King Charles has stripped his brother of all remaining titles and honours. Now he is simply...
At 9:42 this morning, Metropolitan Police officers entered Royal Lodge with an arrest warrant bearing Prince Andrew's name. The charges, filed in a London court just after dawn, stem from evidence that has been quietly gathered for 18 months. The palace's statement, released within the hour, contained two words no one expected to see: guilty plea, the arrest that finally came. The morning began with an unusual stillness at Royal Lodge, the kind of quiet that settles over a place where everyone inside knows something terrible is about to happen. Andrew had been awake since 5:30, sitting in the drawing room where he'd spent so many hours over the past years watching his world contract. He was dressed formally, almost ceremonially, in a dark suit that looked like it had been chosen for a funeral, because in a sense it had been. This was the funeral of whatever remained of his public life, his freedom, and his identity as a member of the royal family. The police arrived precisely at 9:30. 4 Metropolitan Police officers, accompanied by 2 representatives from the Crown Prosecution Service, entered through the private gate to avoid the media presence that had been building since dawn. Word had leaked hours earlier that something significant was happening, though details remained scarce enough to fuel wild speculation across social media and news channels. Detective Chief Inspector Margaret Thornhill, who had been leading the investigation into Andrew for the past year and a half, stepped out of the lead vehicle and approached the front entrance where Andrew's private secretary stood waiting. The exchange was brief and professional. A warrant was presented. Confirmation of identity was requested. And then the words that would echo across every news broadcast for days. Prince Andrew, Duke of York, I am arresting you on charges of conspiracy to obstruct justice and making false statements to investigators. You do not have to say anything, but it may harm your defense if you do not mention when questioned something which you later rely on in court. Andrew, watching from inside, took a long breath and walked to the entrance himself. He had been expecting this moment since his legal team had informed him 3 days ago that the Crown Prosecution Service had decided to proceed with charges. His solicitors had negotiated the terms of surrender, ensuring that he could be arrested at home rather than face public humiliation. But no amount of negotiation could make this moment anything other than what it was: the final, irreversible collapse of a prince who had spent years evading consequences that had finally caught up with him. The drive to the magistrate's court in central London took 43 minutes through morning traffic. Andrew sat in the back of an unmarked police vehicle, staring out the window at a city that had once treated him with deference and now regarded him as something between a criminal and a cautionary tale. There were no sirens, no dramatic pursuit, just the mundane reality of a man being transported to face charges like any other citizen who had run out of protection and privilege. The courtroom where Andrew appeared for his initial hearing was small, deliberately chosen to limit public access while still maintaining the legal requirement of open proceedings. Fewer than 30 people were present: court officials, prosecutors, Andrew's legal team, and a handful of accredited journalists who would file reports within minutes of the hearing's conclusion. Andrew stood as charges were formally read, his face composed but his hands gripping the dock's edge with enough force that his knuckles went white. The charges were specific and damning. Count 1, conspiracy to obstruct justice by deliberately providing false information to investigators regarding his relationship with Jeffrey Epstein and knowledge of criminal activities. Count 2, making materially false statements under oath during a civil deposition conducted in 2023. Count 3, witness tampering in connection with attempts to influence testimony in ongoing investigations. What happened next stunned everyone in the courtroom, including several of Andrew's own legal team who had been working on defense strategies. When asked how he pleaded, Andrew's voice was barely audible but unmistakable. Guilty to all charges. The prosecutor paused as if to question whether she had heard correctly. Andrew's lead solicitor closed his eyes briefly, a gesture that suggested this decision had been made against legal advice. The magistrate, clearly prepared for this development, moved quickly through the procedural requirements. Bail was set at £500,000, secured by assets Andrew still controlled. His passport was surrendered. A sentencing hearing was scheduled for 6 weeks hence on January 23, 2025, and with that, the initial proceeding concluded. By 11:15, Buckingham Palace had released its statement. The King has been informed that the Duke of York has entered guilty pleas to charges filed this morning. This is a deeply regrettable situation. The individual involved is no longer a working member of the royal family and has not been for several years. His actions are his own. The matter is now with the courts, and the family will not be providing further comment. The use of the individual involved rather than Andrew's name or title was deliberate and chilling. The palace was already beginning the process of erasure, treating Andrew not as a family member but as an external problem that had somehow attached itself to the monarchy. That phrase, more than any other part of the statement, communicated how completely Andrew had been severed from the institution he'd been born into. In the United States, where the Epstein scandal had originated and maintained the most intense public interest, reaction was more uniformly critical. American commentators questioned why it had taken so long for British authorities to act, why Andrew had been protected by royal status for years, and whether the guilty plea was part of another arrangement designed to minimize damage to the monarchy rather than achieve justice for the victims. By early afternoon, the reality had settled across the royal family with a weight that felt almost physical. Prince Andrew, son of Queen Elizabeth II, brother to King Charles III, had pleaded guilty to serious criminal charges and would almost certainly be going to prison. And in that moment, something fundamental about the monarchy's relationship with British society shifted irrevocably. The evidence that forced action. The investigation that led to Andrew's arrest had begun not with dramatic revelations, but with the patient, methodical work of forensic accountants tracing financial transactions that Andrew had assumed were buried too deeply to ever surface. The Metropolitan Police's Special Crimes Unit had received authorization in April of 2023 to examine Andrew's financial records in connection with ongoing international investigations into the Epstein network. What they found opened doors that Andrew's legal team had spent years trying to keep sealed. The financial trail showed payments totaling over £2 million made from Andrew's accounts to various individuals between 2010 and 2015. One particularly damaging payment, discovered through cross-referencing with American banking records, had been made just 3 days after Virginia Giuffre's initial public allegations against Andrew in early 2015. But this financial evidence, while compelling, wasn't sufficient for criminal charges on its own. What transformed the investigation from civil liability territory into criminal prosecution was the recovery of communications Andrew believed had been permanently deleted. In September of 2023, Metropolitan Police digital forensics specialists had been granted access to devices and accounts Andrew had used during the relevant period. What they recovered was devastating. Email exchanges from 2014 and 2015 showed Andrew and his advisors discussing strategies for managing witness statements. That email chain, authenticated by multiple technical analyses and confirmed by the advisor who had received it and subsequently cooperated with investigators, formed the basis of the witness tampering charge. Andrew's legal team argued that the communications reflected nothing more than the preparation of accurate testimony. Still, prosecutors countered that there was a clear pattern of attempting to influence recollections in ways that contradicted documented evidence. During that deposition, Andrew made several statements under oath that investigators later proved to be false. He claimed he did not know about Epstein's criminal activities before the financier's 2008 conviction. But recovered communications showed that Andrew had received detailed information about investigations into Epstein as early as 2006 and had discussed those investigations with Epstein directly. Most damaging was his testimony about a specific photograph showing him with Virginia Giuffre. Andrew had suggested the photograph might be fake, that he had no memory of it being taken, and that he had never been to the location where it appeared to have been photographed. Each false statement taken individually might have been explained as a case of faulty memory or confusion, but the pattern, especially when combined with evidence that lawyers had advised Andrew before the deposition to be strategically imprecise about potentially damaging details, constituted deliberate false testimony. Prosecutors had built their case methodically, showing that Andrew hadn't simply misremembered. He had lied repeatedly and deliberately to avoid legal consequences. The American dimension of the investigation had been crucial. FBI agents working with Metropolitan Police counterparts had provided access to evidence collected during American investigations that couldn't be used in U.S. prosecutions due to various legal technicalities, but could be shared for UK proceedings. This included witness statements from individuals who had declined to testify publicly but were willing to speak to law enforcement confidentially. Perhaps most significantly, investigators had discovered that Andrew had instructed staff to destroy certain documents and communications in late 2019, shortly after Epstein's demise and the subsequent intensification of investigations. Several former Royal Lodge employees, interviewed under caution, confirmed they had been directed to delete email accounts, shred paper files, and remove hard drives from computers Andrew had used. While Andrew's lawyers insisted this was routine security protocol, prosecutors argued the timing and thoroughness suggested consciousness of guilt and an attempt to obstruct future investigations. The Crown Prosecution Service had spent months reviewing this evidence, consulting with senior counsel about the strength of the case and the public interest in prosecution. The decision to proceed had not been taken lightly. Prosecuting a member of the royal family, even one who had been stripped of titles and roles, carried immense political and constitutional implications. But ultimately, prosecutors had concluded the evidence was overwhelming, and that failing to act would send an unacceptable message that royal status placed someone above criminal accountability. When Andrew's legal team was shown the full scope of evidence at a disclosure meeting 3 weeks ago, their strategy shifted immediately from defending innocence to negotiating the least damaging guilty plea possible. But because it was the only rational choice remaining to someone who had finally, definitively, run out of places to hide from the consequences of his own conduct. Why the family couldn't protect him this time? The decision that the royal family would not attempt to shield Andrew from prosecution had been made during an emergency meeting at Windsor Castle on November 28th, 3 days before the arrest. Charles had convened William, Anne, and his most senior legal and constitutional advisors to discuss a situation that had suddenly escalated from theoretical possibility to imminent crisis. The Crown Prosecution Service had informed the palace through formal channels that charges were being filed and that Andrew would be arrested within 72 hours. The notification had been a courtesy, a recognition of the constitutional implications, but it had not been a request for permission. Anne had been the first to speak, and her position was characteristically unambiguous. "We cannot protect him. We should not protect him. He's committed crimes, and the evidence appears overwhelming. If we attempt to shield him now, we destroy whatever credibility the institution has left." William's position had been equally firm, though expressed with more visible struggle. Andrew was his uncle, someone he'd known his entire life, but William's loyalty to the institution and his understanding of modern monarchy's survival requirements overrode any familial sentiment. King Charles had listened to both his sister and his son, knowing they were right but feeling the weight of what that rightness demanded. He would be the first British monarch in modern history to allow a sibling to be prosecuted and imprisoned. The legal advisors had laid out the options with clinical precision. The palace could, in theory, attempt to influence the prosecution through various back-channel mechanisms. They could apply pressure on the Attorney General, suggest that prosecution wasn't in the public interest, or argue that royal status created unique circumstances warranting special consideration. But each of these options came with enormous risks. If the attempt became public, and in the current investigative media environment it almost certainly would, the palace would be accused of corruption, of using royal privilege to obstruct justice, and of valuing family protection over legal accountability. Alternatively, the palace could fully cooperate with the prosecution, providing access to any relevant information in royal household records and publicly supporting the legal process. This option would demonstrate that the monarchy respected the rule of law and that royal status provided no shield against criminal accountability. It would be devastating for Andrew and traumatic for the family, but it would protect the institution's long-term credibility. Charles had posed the question that haunted him. What would my mother have done? Anne's response had been immediate. She would have protected him. She protected him for years, and it cost the monarchy dearly. You have the chance to make a different choice. Make it. There was also the matter of royal finances. Andrew's legal defense over the past years had been partially funded through family resources, a fact that had been kept quiet but would inevitably surface during criminal proceedings. Charles faced a decision about whether to continue that support or to cut Andrew off completely, forcing him to rely on whatever personal assets he had left after settlements and legal fees had depleted his resources. William had argued forcefully for complete financial severance. If we continue paying his legal bills while he defends criminal charges, we're complicit. Every pound that comes from royal sources to protect him is a pound that should be spent on legitimate charitable work or returned to taxpayers. We can't subsidize his defense of indefensible conduct. Charles had agreed, though the decision meant Andrew would face sentencing with significantly diminished legal representation. The discussion had extended over 4 hours, breaking only when Charles needed to take a call from the Prime Minister, who had been briefed on the impending arrest and wanted to coordinate government and palace responses. By the time the meeting concluded, the decision was final. The palace would issue a brief statement acknowledging Andrew's arrest and guilty plea, would provide no financial or legal support beyond what had already been committed, and would cooperate fully with any requests from investigators or prosecutors. Andrew would face consequences alone, without the institutional protection that had shielded him for so long. But Charles had insisted on one element of mercy, if it could be called that. He had instructed his private secretary to inform Andrew personally before the arrest occurred that the family would not be intervening. That conversation, conducted by phone on the evening of November 30th, had been brief and devastating. Andrew had reportedly asked whether there was any possibility of support, any way the family might help mitigate what he was facing. The response, delivered in Charles's private secretary's carefully neutral tone, had been final. His Majesty has determined that the institution's interests require that you face legal proceedings without royal assistance. This decision is not subject to appeal or reconsideration. What Andrew had said in response was not recorded, but those who spoke with him afterward described a man who had finally understood that his royal birth, the status he had spent his entire life leveraging and hiding behind, would not save him this time. The protection had ended. The consequences had arrived, and the family, the institution, the crown itself, had chosen survival over loyalty, future over past, and accountability over the privilege that had allowed Andrew to evade justice for far too long. Sarah Ferguson's devastating position. Sarah Ferguson learned about Andrew's impending arrest not from Andrew himself, still from a phone call at 7:20 on the morning of December 4th, just 2 hours before police would arrive at Royal Lodge. Sarah's response was silence, followed by a question. "Is he guilty?" The private secretary hesitated before answering carefully. "He's pleading guilty to the charges. Whether that reflects actual guilt or legal strategy, I cannot say." Sarah's next question cut to the heart of the central dilemma of her life. What am I supposed to do? Within hours of Andrew's arrest, Sarah's publicist had been inundated with requests for comment. Would she stand by Andrew? Would she attend the sentencing hearing? Did she believe he was guilty? Every answer carried risk. Supporting Andrew would associate her with a convicted criminal and potentially destroy the reputation she had spent years rebuilding. Abandoning him would make her look disloyal and could permanently damage her relationship with Beatrice and Eugenie. The meeting Sarah convened that afternoon included her closest advisors, her lawyer, and representatives from the 2 charities where she served on the board. The charity's message was clear and devastating. If Sarah remained publicly associated with Andrew, they would have no choice but to ask for her resignation. Donor pressure was already building, and organizations focused on women's welfare and abuse prevention could not have a board member connected to someone convicted of crimes related to the Epstein network. Her lawyer laid out the legal dimensions with equal bluntness. While Sarah faced no criminal liability herself, she could be called as a witness in future proceedings, either in UK courts or potentially in American civil cases that remained pending. The question facing Sarah was whether to formally separate from Andrew, issuing a statement that created clear legal and public distance, or to maintain some version of the ambiguous connection they'd preserved for years. Her advisors unanimously recommended formal separation. Sarah read the statement and set it down without signing off on its release. "I need to talk to my daughters first. I can't make this decision without them." That conversation, held that evening with Beatrice and Eugenie present via video call, would be described by one participant as the most emotionally raw discussion the family had ever had. The conversation with her daughters stretched past midnight, moving from legal strategy to raw emotion and back again. Sarah cried, something she rarely did in front of her daughters, and confessed that she didn't know how to be loyal to Andrew without destroying herself. "I've stood by him through everything, the scandals, the humiliation, the financial disasters. But this? How do I stand by someone who's admitted to obstructing justice and lying under oath? What does that say about me?" Beatrice had offered a perspective that ultimately shaped Sarah's decision. Standing by him now isn't loyalty, it's complicated. You can love him, you can visit him in prison if you want, but you can't publicly defend or associate with what he's done. That's not about him. It's about you and us, and whether we can have futures that aren't defined by his mistakes. By the time Sarah released her statement 2 days later, it had been revised to remove the phrase about ending the relationship, replacing it with language that created distance without complete severance. Recent developments concerning the Duke of York represent a personal tragedy for him and those who care about him. "I will continue to support my daughters through this difficult time while respecting the legal process that must now unfold. I ask for privacy as we navigate these painful circumstances." The statement satisfied no one fully, as Andrew's remaining defenders saw it as betrayal. His critics saw it as an insufficiently clear distance, but it achieved what Sarah needed most. It allowed her to maintain some connection to Andrew and support for her daughters while creating enough separation to protect her own future. The practical consequences arrived swiftly. The charities accepted her continued board membership, but quietly moved her to non-public roles. Speaking engagements were canceled or postponed indefinitely. And most significantly, the Crown Estate confirmed that Royal Lodge would need to be vacated within 6 months, forcing Sarah to confront the reality that the home she'd lived in for 2 decades was no longer available to her. The financial dimension was catastrophic. Sarah had been living partly on Andrew's support, which came from the late Queen Elizabeth's private funds, and that support would now cease. Her daughters, watching their mother struggle, had their own parallel crisis. Beatrice, married and establishing her own family, worked to maintain a clear distance from her father's situation while supporting her mother. Eugenie, more publicly associated with Andrew through years of defending him, faced questions about whether her own judgment had been compromised by family loyalty. Both would spend years untangling their identities from their father's crimes, carrying the burden of his conviction into their own children's lives. The woman who had once been Duchess of York, who had survived divorce and financial scandal and public humiliation, now faced the hardest challenge of her life: surviving the consequences of standing too close to someone whose fall had finally become terminal. Whether she would succeed, whether she could build a life beyond the shadow of Andrew's conviction, remained an open question that would define her remaining years. The legal reality Andrew now faces. The sentencing hearing scheduled for January 23rd would determine precisely how many years Andrew would spend in prison. Still, legal experts analyzing the charges and guilty plea could already outline the parameters with reasonable accuracy. Under UK sentencing guidelines, the combination of crimes Andrew had admitted to carried a potential maximum of 14 years imprisonment. The first charge was the most serious. UK law treats obstruction of justice as a direct attack on the legal system itself, and sentences reflect that severity. Andrew's specific conduct, attempting to influence witness testimony and destroying potential evidence, fell into the higher range of culpability. The sentencing guidelines suggested a starting point of 4 to 7 years for offenses of this nature, before adjustments for mitigating or aggravating factors. The false statements charge added additional time. While perjury and false statements were sometimes treated leniently in civil proceedings, the materiality of Andrew's lies, their direct impact on the legal proceedings, and their connection to serious underlying crimes elevated them to serious offenses. Legal analysts estimated this charge would add 12 to 18 months to his overall sentence. Andrew's guilty plea would reduce his sentence by approximately 25 to 30% from what he would have received after trial. This was standard practice in UK criminal justice, incentivizing guilty pleas to reduce court time and spare witnesses the trauma of testimony. His legal team had negotiated this reduction as part of the plea agreement, ensuring the judge would consider it during sentencing. But several factors worked against Andrew receiving the minimum possible sentence. His lack of genuine remorse was another complicating factor. The guilty plea, while legally significant, was framed entirely by his lawyers in pragmatic terms, as a pragmatic acceptance of the evidence against him rather than an acknowledgement of wrongdoing or concern for victims. Sentencing judges typically differentiate between defendants who accept responsibility and express remorse versus those who simply acknowledge they've been caught. Andrew fell firmly in the latter category. The sentencing process would occur during a single-day hearing, during which the prosecution and defense would present arguments for an appropriate punishment. The Crown Prosecution Service would emphasize the seriousness of Andrew's crimes, their impact on legal processes, and the need for sentences that deter similar conduct by others in positions of power. Andrew's defense team would highlight his guilty plea, his cooperation with authorities following arrest, and argue that his fall from public grace constituted punishment beyond the formal sentence. The victim impact component of sentencing posed additional unique challenges. While Andrew's convictions related to obstruction and false statements rather than direct abuse, his conduct caused prolonged pain for victims seeking accountability through legal processes. Several women who had been involved in Epstein-related litigation submitted written statements describing how Andrew's interference had delayed their cases, traumatized them further, and made seeking justice more difficult. Prison allocation would be determined after sentencing, but before Andrew began serving his term. His status as a former working royal created security concerns that would likely lead to placement in a facility with segregated units for high-profile prisoners. He would not receive special privileges or treatment because of his background. Still, practical security considerations would prevent him from being housed in the general population, where he could be targeted by other inmates seeking notoriety or expressing anger about his crimes. The conditions Andrew would experience in a UK prison were far removed from any lifestyle he'd previously known. Parole eligibility would begin after he'd served half his sentence, provided he'd maintained good behavior and complied with prison requirements. However, parole boards typically require demonstration of remorse and rehabilitation that Andrew had shown no indication of possessing. Legal experts suggested he would likely serve at least 2/3 of his sentence before release, possibly more if his conduct in prison or lack of acknowledgement of wrongdoing concerned parole officials. The international dimension remained unresolved. American civil cases against Andrew remained pending, and his guilty plea in the UK criminal court could be used as evidence in those proceedings. Plaintiffs could argue that Andrew's admission of lying under oath rendered his testimony in civil matters unreliable, and that his conviction for obstruction demonstrated consciousness of guilt regarding the underlying conduct. These cases would proceed regardless of his imprisonment, potentially resulting in additional financial judgments against him. As January 23rd approached, legal observers anticipated a sentence in the 6 to 7 year range, with Andrew likely serving 4 to 5 years in prison before potential parole. It was a stunning fall for someone who had once been seventh in line to the throne, who had lived his entire life surrounded by privilege and protection. The monarchy after Andrew's fall. The constitutional questions raised by Andrew's conviction and impending imprisonment were unprecedented in modern British history. The first immediate issue was Andrew's place in the line of succession. Technically, a criminal conviction did not automatically remove someone from succession under the existing law. The Act of Settlement from 1701 and subsequent succession legislation focused on religious requirements and marital legitimacy, but said nothing about criminal status. But the palace recognized that allowing a convicted criminal to remain in succession, however distantly, was constitutionally untenable. Charles authorized his legal team to prepare letters patent formally removing Andrew from the succession, a process that required extensive legal drafting and would be made public in the weeks following sentencing. This would mark only the second time in modern history that succession had been formally restricted through letters patent rather than a parliamentary act. The question of Andrew's titles presented another challenge. He had already lost his HRH styling and could no longer use Duke of York in any official capacity. Still, the title itself remained attached to him legally, unless formally removed through an act of Parliament. Several MPs had already indicated they would introduce legislation stripping Andrew of all titles and styles, making him simply Andrew Mountbatten Windsor, private citizen and convicted criminal. The royal family's approach to Andrew's future would be complete erasure. Photographs of Andrew in official royal residences were being removed or replaced. References to him in official royal family materials were being edited to remove his presence while maintaining historical accuracy about events. The palace was undertaking what one insider described as careful amnesia, acknowledging Andrew's existence when necessary, but removing any celebratory or positive references to his role in royal history. The impact on Charles's reign was significant and would be lasting as he had become king amid hopes that he could modernize and stabilize an institution facing questions about its continued relevance. Now, less than 3 years into his reign, he was overseeing his own brother's imprisonment. The optics were devastating, and no amount of careful messaging could obscure the reality that the royal family's judgment had been catastrophically flawed. William, preparing for his own eventual reign, was already implementing lessons from the Andrew crisis. His vision for the monarchy's future involved dramatically reduced numbers of working royals, stricter accountability for those who remained, and a willingness to sever family members who brought the institution into disrepute. Andrew's conviction had not created William's philosophy, but it had vindicated and strengthened it. The streamlined, ruthlessly professional monarchy William envisioned had no place for individuals who prioritized personal privilege over institutional responsibility. The international implications were equally significant as the Commonwealth nations, several of which had been considering removing the British monarch as head of state, now had additional ammunition for Republican arguments. How could a modern nation accept as constitutional head of state a family that had protected a criminal for years and only acknowledged accountability when forced by legal process? Caribbean nations in particular accelerated discussions about transitioning to Republican governance. For the institution itself, the question was whether it could survive the accumulated damage. Andrew's conviction came after years of Harry and Meghan, persistent questions about royal finances, and declining public deference toward hereditary privilege. Each scandal individually had been survivable, but the cumulative effect was creating a kind of legitimacy crisis that no amount of dutiful public service by William and Catherine could fully offset. The monarchy had survived existential crises before, from abdication to divorce to the death of Diana. Each time it had adapted, reformed just enough to maintain public support, and continued. But each survival had come at a cost, and the accumulated costs were making the institution more fragile, more dependent on the personal popularity of individual royals rather than reflexive support for the crown as an institution. As Andrew prepared to enter prison, the monarchy prepared for a future defined by his absence and the questions his crimes raised. Can an institution based on hereditary privilege and unearned status survive in a society increasingly committed to accountability and merit? Can a family that protected a criminal for years claim moral authority or leadership? Can traditions stretching back centuries adapt quickly enough to remain relevant in a world that judges them by contemporary standards of justice and equality? These questions had been debated academically for decades. But now, with a prince heading to prison and the institution reeling from self-inflicted wounds, they were no longer academic, but immediate, pressing, and potentially existential. The monarchy would survive Andrew's conviction in the technical sense of continuing to exist. Whether it could survive with its legitimacy and public support intact was the question that would define the next chapter of an institution that had endured for over 1,000 years, but now faced challenges its medieval founders could never have imagined.